Any mention?
Right, please, Your Lordship.
Yes.
Your Lordship, I beg to mention item number 17 and number 18, Your Lordship.
17
and 18, Your Lordship. On behalf of the private respondent, Your Lordship.
Well, there is just one prayer that today it's okay, I don't object to the adjournment being sought. But
on behalf of the private respondent.
Yes, Your Lordship.
they should at least inform the previous day, my lord. I have travelled only for this matter, my lord.
That is one thing actually you should sort out. Actually, that is normally expected. You should inform the other parties.
Yes, Your Lordship.
See, that should be the convention. You see, like it should be the practice here. After all, you are lawyers. You should have those kind of things.
Lord, for today I don't raise an objection, but
Yes. When do you want it?
After 2 weeks, my lord.
17, 18.
I'm appearing in 18, Your Lordship.
Oh, your names will be all will be recorded. Appearances will not go.
I'm appearing
Here
on
for the
behalf of
petitioners. Here for the petitioners. Please record everybody's name. And then so on the request made by the learned counsel for the private respondent. This matter after 2 weeks.
Duty, Your Lordship.
Hey, please, Your Lordship, I beg to mention item number 11.
Yes.
Pray for 2 weeks' time, Your Lordship.
My Lord, I appear only for the state respondents 1 to 3, my Lord.
You're objecting.
No, my Lord. See, they have
why
already
you are not
informed me.
objecting?
They have already informed me, my Lord.
They will inform. That's why you're not objecting.
My Lord.
Okay. On the request made by the learned counsel for the petitioner. List after 1 week.
2 weeks' time, Your Lordship.
2 weeks. 11. List. Yes.
Much obliged.
Lordship, I beg to mention item number 12. I pray if this matter may come up after 2 weeks, Lordship.
You're appearing on behalf of the state.
On behalf of the state. Mr. Chula is conducting counsel in this matter. He's indisposed, Lordship.
No objection, Your Lordship.
Okay. This will be expressed prayed for by the learned counsel for the state respondent. List this matter after 2 weeks.
Highly obliged.
May it please Your Lordship.
Yes.
Lordship, I beg to make a mention of item 5.
Only item 5.
Lordship, 5 and 6 are connected, Lordship.
The 2017 matters.
Lordship.
5 and 6 are not connected matter, Lordship. Different matters.
Lordship, they're always stacked together.
5 and 6.
Lordship.
Tagged together.
Lordship.
together, but it's not a similar matter.
So why it is tagged together then?
I don't know. That is the prayer made by the petitioner.
You are appearing in 6 also?
Lordship, for the private response.
These are what? Nakma?
Gaunpura matter, Lordship.
Lordship, in item 5 is the regard to the suspension of Gaunbura admin. Now, in item 6, that is
Suspended in 2017. Any interim order?
No, Lordship.
No, Lordship.
She is out of power from 6 years. For 6 years now.
Lordship.
What remains then in the matter then?
Now, in item 6, this is a land matter.
Anyway. 5 and 6. Request made by and request made on behalf of the petitioner. Release this matter after 2 weeks.
2 weeks, Lordship.
2 weeks.
Lordship, a similar prayer for item 10, Lordship.
Item 10.
Lordship.
Who is in item 10?
I'm appearing on behalf of the respondent.
Oh, that matter.
It's the same matter.
It's been adjourned for no reason actually.
Or
Okay, we'll just see. This also on the request of the petitioner, list after 2 weeks. Then
Highly obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 8. Actually, what happened, Lordship, on 25/9, we are supposed to file the affidavit, but we are not aware of the fact that verification is needed. Then we again go to Guwahati and collect it from the verification. And today, when we came to submit it, we are informed that should be on the both side of the A4 size paper.
you should basically verify before you.
Actually, yeah, Lordship.
It is what? Rejoinder affidavit?
Lordship. If your Lordship
Yes, Mr.
permit,
Karwalang, is it rejoinder?
No, Lordship's reply. We had filed affidavit bring on record a tripartite agreement.
tripartite
And
agreement.
they had filed, this is the reply they wanted to file. Lordship had granted a leave to file the reply.
There
on-
exists an order allowing them to file affidavit.
Yes, Lordship, and this was last year of November.
Until now, they have not filed.
Lordship, is 1 year's already passed, Lordship.
Lordship, if Lordship permits, then we can submit it like this on single side.
See, if the procedure says something, there is no question of court giving you permission.
Lordship.
You have to go by that, the requirement.
Lordship, then one last chance may be given, Lordship.
Okay, Miss so appearing for the petitioner. Please for grant of further 2 weeks time. You are having objection?
Except for that, Lordship, that already 1 year's time has already passed since.
So you then
Leave was granted.
we'll record your objection if you have objection. then-
Lordship. Lordship can record that objection, Lordship.
Yes, Mr. Please for grant of further sticks. Mr. Karwalang appearing for the state respondents. He raises objection against the plea and submits that the petitioner has failed to file a reply affidavit for last almost 1 year.
Lordship.
Stop. However, for the ends of justice, the petitioner is afforded one more chance to file a reply affidavit. Stop. List after 2 weeks.
Highly obliged, Lordship.
Lordship.
May it please, Lordship. Lordship, I beg to mention item number 4, Lordship. Lordship, this issue is still pending before division bench, Lordship. So, Lordship, this matter may come up after 3 weeks, Lordship.
That, has it been recorded any time that there is a similar matter pending for division bench?
Yes.
It is recorded.
It is recorded, Lordship.
This matter pertains to what?
This is land acquisition.
Land acquisition matter, Lordship. That ROW is involved, Lordship. Regarding that ROW, Lordship. Right of way.
What is the last order passed in that? You wait, let the matter be called.
Lordship.
Just wait for the time.
May I please, Your Lordship? I beg to mention item number 14, Your Lordship. I pray for 3 weeks' time. It's a joint request, Your Lordship.
Joint request.
Yes, Your Lordship.
On joint request made by the parties. We'll list this matter after. When?
3 weeks, Your Lordship.
3 weeks. 14, 3 weeks, after 3 weeks. Yes.
May I please, Your Lordship, I beg to mention item number 9.
Nine.
9. Mr. Shen is there.
Lordship, they were required to file an affidavit. We've received that.
Okay, affidavit with regard to the
Going
law.
on record certain documents. This was an order passed in the month of June.
Have they filed?
We filed it.
So then,
After 2 weeks, Your Lordship.
Mr. Yuban is not in station today. He's informed me. Any date which is convenient to Lordships.
no. You see, convenient, it should be convenient to you.
Lordship. Can have it this week also. I've got a feeling.
Leave to file reply.
Okay. This number 9 will be list after 2 weeks on the request made by the learned counsel for the petitioner. Will come after 2 weeks.
Obliged.
Lordship, I beg to mention item number 7. Similar matters are pending before the Apex Court.
That is what has been recorded. We'll just see, just wait for the timing. We'll just see the record, what is there in the last order.
I do.
Thank you, Lordship.
Yes, Bandhi.
Lordship, I beg to mention Article 16, Lordship. 16. In fact, my Lord, restatement number 2, notice was served, and in fact, they were supposed to file the power. It seems they have filed the power today, Lordship.
We filed the power today, Your Lordship.
You are entering appearance.
Yes, Your Lordship.
You have the power.
Yes, Your Lordship. We've already filed.
Then?
For respondent
Then
number
what is to be done?
Madam, we proceed for hearing. My Lord, respondent number 3 has not appeared.
No, it is already there in the hearing list.
Yes, Lordship.
So we can proceed for
We
hearing.
can proceed for hearing, my Lord.
So you will be taking it up. What is the purpose of mentioning?
My Lord? Actually, I was praying for 2 weeks' time, Lordship. Since
That is
they have appeared
exactly
today, and my Lord may now proceed the matter for hearing, my Lord, after 2 weeks. My Lord.
That's, it is already in the hearing list, so definitely
Yes,
we'll proceed
yes,
for hearing.
yes, Lordship.
So you need not say it again. Only thing is that if you want time, that you can tell us. Then we
Lordship. I'm praying for 2 weeks' time, Lordship.
State has no objection. Okay, item 16.
16.
Isn't it? On the request of the learned counsel of the petitioner, list after 2 weeks.
Right.
May I please, Your Lordship? Your Lordship, I beg to mention item number 13.
Yes, you are appearing for?
I'm appearing for respondent, Your Lordship.
Private respondent.
Yes,
Private respondent.
yes, Your Lordship. I'm praying for 2 weeks' time, Your Lordship.
This is criminal petition for what?
482, Lordship, for quashing of the FIR, Lordship.
Okay, 13. On the request made on behalf of the private respondent, list after 2 weeks.
Yes, Your Lordship.
Lordship, may I please, Lordship? Lordship, I beg to make mention for item 20, Lordship.
Anything remains? Not. Yes.
Item 20, Lordship. Beg, pray for 2 weeks' time, Lordship.
20, who is for the other side? Who is the other side?
Sir Singh Gupta, Lordship. Sir Singh Gupta.
Where is he?
I'll inform, Lordship.
Yes.
The conducting counsel is Mr. Sengupta. He's on his legs. For the
Whether
I'll inform, Lordship.
making prayer for adjournment. Any objection to that?
No objection. No objection.
Okay, then 20 also on the request of the learned counsel of the petitioner. List after 2 weeks.
Really obliged.
Obliged.
Item number 1. Please, Lordship. This matter, I pray your indulgence to have this matter also some other day, because today I have some appointment with doctor.
What is this matter about?
Actually, this is regarding the petition filed by the complainant and also the accused person for compromise, alleging that he was kidnapped.
You are seeking quashing?
Yes, Lordship.
The private respondent has appeared?
Private respondent have appeared.
You are appearing for private respondent in this matter?
Mr. Sheikh is in this case.
He's not. He's absent today, Mr. It's all right. Petitioner is asking for time. We'll get it listed for hearing.
Lordship.
Yes. Hard learned counsel for the parties. It is submitted that the matter is ready for hearing. List this matter for hearing after 2 weeks.
Much obliged, Lordship.
Much obliged, Lordship.
Item number 3.
But here, my lord, 2 writ petitions are pending. My lord,
what is this application about?
File for vacating the interim order, my lord.
2019?
19, my lord. My lord, this was a case of reversion to his parent department, my lord.
Somebody is appearing through VC.
Lordship, the main writ petition is fixed on 16th. And like the matter may be heard together on 16th.
The main petitions are ready for hearing.
For
it's ready
final.
for a long time.
Then, why should we?
My lord, on 16th it's fixed on 16th.
Lord,
So it will be
is,
like it can be disposed of on 16th after final hearing. It can be listed for like final disposal
On the
on
last
16th. It's
occasion
already
when the
listed on
request for
16th.
adjournment was made, you have not raised any objection in the main case.
Yes, Lordship. Mr. Bonnik is actually
Yes.
conducting
Please,
the case.
hold on.
However, due to some personal
Please hold on. Please hold on for a minute. Please.
My lord.
See, on the 20th October, 3 weeks time was given on the prayer of the petition. There is nothing to show that any objection was made on your behalf. If this matter is coming up next week, then we
My lord,
But the main, what is submitted, the main matter is coming on 16th, my lord. Can we list it together? The entire matter can be disposed of. I'll not press for this.
2 writ petitions are taken together along with 418. There is another one, 461.
Other one
of
is also
2020.
listed.
Both are taken together and
What is it?
yes, my lord. It's both are taken together on 16th, so it may be heard on 16th for final disposal, my lord. Mr. Bonnik will be there in Shillong on that day.
Check now when is the next date for both the matters. I don't understand.
So we'll have it on 16th then. It is submitted that the main petition
Obliged, my lord.
is also ready for final disposal. It is ready for final disposal. Not also you did not give also. Okay. It is submitted there. The main petition is ready for final disposal and is likely to be listed on 16th November 2023. In view of the submission, list this miscellaneous application also the same date, so that the same can be taken up together for disposal.
Much obliged, my lord.
Hearing item number 4.
There is an order on 1st June 2023.
In this matter,
My lord, the last order also says so, sir.
it has been submitted by the parties that the matter pending before division bench having a bearing in the present case is yet to be disposed of. The parties pray that matter be adjourned for 4 weeks. Matter be adjourned. Stop. Accordingly, this is matter after
4 weeks, my lord.
4 weeks. Yes.
Highly obliged.
Item number 7.
Yes. This is also Apex
Yes,
Court.
Lordship, the connected matters are pending before the Apex Court. It was reflected in the order dated 12/10/2023 as well as order dated 17/5/2023.
Okay. Well, still to wait. For
A batch of around 20 matters were disposed of at division bench, my lord. Against that, we have gone on appeal, my lord, SLP. Department is gone.
This will have a bearing. This will be covered by
direct bearing.
This will have a direct
Same point of law.
Okay. It is submitted that the connected matter pending before the Apex Court is yet to be taken up for final disposal. In view of the submission, list this matter after 4 weeks.
Item number 15.
What happened, well, 20 writ petitions, there are around 500 private respondents. The writ petition, their notice is not complete on this. It will take some time. Yes.
15.
Yes, Mr. Kinta.
Lordship, we did extensive research, and 2022 there is an article. It is in SCC online, and it will be of assistance to the court as well as to everybody.
So you will be placing it on.
Yes, yes.
You can give us.
May it please your Lordship? Lordship, I brief the matter may come up at the end of the board. Mr. KP Bhattacharjee, he's on legs in courtroom number 2.
But do you have any other matter after this?
19, I think is there.
You can wait for sometimes. Okay. Yes, at the end of the board.
19.
Wait, please, Lordship.
Yes, Mr. Shalla.
Lordship, I'm before your Lordship for quashing of one criminal case that is pending in the Session Court of Joy. I've been charged in that case under Section 307, Section 326, Your Lordship.
Attempt to murder.
Yes, Your Lordship.
And grave assault.
Yes, Your Lordship. Yes. Lordship, before I take Your Lordship to the materials that is on record, Lordship, I'll just, with your permission, brief this Honorable Court as to the background relating to the facts and the brief background as to the law involving the matter.
Yes, please.
Lordship, in this case, on the 21st of February 2017, an incident took place between myself and the respondent number 3, who are related to one another. In fact, I am the cousin brother of the father of the victim in this case. So on that said day, it has been alleged that myself along with the respondent number 3 went to one house, and then we started drinking alcohol along with several other people there. And there, all of a sudden, I started beating this victim with a da, causing injury to him.
That is the allegation.
That's the allegation. On the same day...
Or admission.
Allegation. And the same day, Your Lordship, he was taken to hospital, where in a nearby hospital. And after that, 2 days after that, an FIR was registered against me. 1 day after the incident, I came to learn through the village defense party, because this incident took place in a village. In a village, there is a setup, Your Lordship, where we have a village defense party who's coordinating with the police and everything. So from them, I came to learn that an FIR has been lodged against me. So thereafter, I did not abscond, but immediately I cooperated with the village defense party and I was taken to the police station wherein I was arrested. I was there in jail for almost 3 years, Your Lordship. More than 1,000 days I was in jail. So, Your Lordship, thereafter what has happened, the charge sheet was filed, charge was framed under 307, 326 and trial commenced. So in the meantime, what has happened, Lordship, the family ties between the two parties has soared because of this particular incident. So with passage of time, good sense prevailed and both sides wanted to have to normalize the family ties. So accordingly, with the intervention of friends and well-wishers, so a compromise deed was executed wherein both sides has expressed their desire to settle the matter. And accordingly, Your Lordship, a compromise deed was executed on which it was agreed that a quashing petition will be filed before this Honorable Court so that the good relationship can be maintained between the family members. Lordship, so far as the law, that is the brief background of the factual aspect. So far as the legal aspect concerning to the matter at hand, Lordship, there are various judgments relating to quashing, but so far as attempt to murder 307, we have specific judgments on this.
2014.
Lordship, yes, 2013, 2014, and finally 2019.
2019.
Yes, the latest is 2019, Lordship. It's a 3-bench. 2014 is a 2-bench. 2013 is a 2-bench, whereas the 2019 is the 3-bench, Lordship. In fact, 2019 judgment, the name of the judgment is Lakshmi Narayan. There, Your Lordship, matter was referred under the pretext that there's two conflicting judgments of the Honorable Supreme Court. 2013, it said that the Supreme Court did not allow quashing of 307 cases, whereas in 2014, the Supreme Court has allowed. That's why, because there was a conflict of this judgment, that's why this matter was...
Was it not something like that, where once Supreme Court allowed some compounding,
yes,
in case of non-compounding offences, and then the subsequent decision said that it is, once it is not compoundable, it cannot be compounded.
No, actually the first judgment
then
also...
can be quashed only in
yes,
case of this.
Yes, actually, Your Lordship, the first judgment also, it did, if we read between the lines, the first judgment, 2013, says that, yes, it can be allowed, but due to the facts and circumstances of the case, the quashing was not allowed, Lordship. That was clarified in 2019. 2019, finally, when we are in 2019, Lordship, the Supreme Court has clarified this aspect that, yes, 307 can be quashed depending on the facts and circumstances of the case, but what needs to be looked into is, firstly, we have to see the injury, the nature of injury inflicted on a person. Secondly, the weapon use, and thereafter the conduct of the accused, and also the antecedent of the accused, beside other factors, Lordship. So basically, that is the law, Lordship.
What is the injury suffered by here, the victim?
Lordship, here, if we look at the face value from the medical report itself, it says that he has suffered some injury in scalp and that the injury is grievous in nature. But
how long he was in hospital?
For around 1 week.
How was it treated as injured patient?
Around 1 week, Lordship. There was no major surgery, nothing as such, Lordship. But he was just in the hospital for 1 week, thereafter discharged, and now he is in fine health, Lordship.
And what is the weapon used?
What allegation is da, Lordship. We have used a da in this case. So basically, on these are the parameters of the Honorable Supreme Court, Your Lordship. So I'll try to satisfy Your Lordship as to why this particular case needs to be quashed. Lordship, for that, firstly, we'll go to, with your permission,
Victim
Lordship.
is private respondent.
Yes, yes,
Victim
Lordship.
is private respondent.
Complainant as well as
supporting
victim.
the case. You are supporting the case of the petitioner?
The complainant is the brother, whereas he is respondent number 2, and the victim is respondent number 3, Lordship. So both of them have been impleaded in this case, Lordship. So, Lordship, to be able to apprise the matter, I'll take Your Lordship firstly to the FIR, Lordship. Lordship, FIR is at page 13, Lordship. This is the translated copy. The original copy is in page 14. This is in Khasi, Lordship. So we have translated it and it's in page 13. Lordship, with permission, I may read. With reference to the subject cited above, I, Shri so-and-so, residing in so-and-so, I furnish this information as under. That on the 21st February 2017 at around 8:30 p.m., I received phone call from my nephew, Shri Riman Lamare Thangrain. He informed me that my brother so-and-so was assaulted by so-and-so, who's the son of so-and-so, by dashing with a dao from his head, and he is seriously injured, and now he is admitted in Joy Civil Hospital, Joy, for getting treatment. That Shri Kanifas assaulted my brother without any reason, and the act is illegal with an intention to cause injury and kill him, and he assaulted my brother at a place known as Kle Sniriam. That Shri Kanifas was hidden, and this shows that he has the intention to kill or cause serious injury to my brother. That the delay in lodging the affair is because I do not get to inquire from my brother as to the reason why he was assaulted, because the doctor do not allow him to speak, as well as he cannot speak properly, but only yesterday night that he told me all the truth, and from that reason I lodged this affair today. So this is the allegation against me, Lordship. Lordship, I'll take your Lordship to the medical report, Lordship. This medical report, Lordship.
Case was registered under what section thereafter?
326, 307, Lordship. Same section under which I'm charged right now, Lordship. Lordship, this FIR was lodged 2 days after the incident, Lordship. Incident was on the 21st.
We are not arguing on merit right now.
Yes. I'm just apprising this court, just the background, Lordship. But the medical report, Lordship, medical examination was done on the same day, on the same day of the incident when he was taken to the doctor. That is as Annexure 1.
Medical report is Annexure 1.
Annexure 1, yes, Lordship. Page 11. Annexure 12 is the medical report submitted to us, but we have typed that, Lordship.
Yeah.
11. Here they have mentioned injury to scalp site is 32. It's not really clear, Lordship, that's why we have not been able to type it. But what is apparent is that there is an injury in the scalp, and also, as mentioned, has consumed alcohol, Lordship. And the opinion of doctor is grievous head injury. Since the parameters of the Supreme Court is primarily on the injury part, Lordship, that's why I'd like to take Lordship to the deposition of the doctor, because doctor has been examined in this case. Lordship, before I proceed with the doctor, one aspect I would like to highlight before this Honorable Court, Lordship. Initially in 2014, when the Supreme Court allowed the quashing of these proceeding under 307, the Supreme Court therein has said that it'll be better for a person to come immediately after FIR is filed. Then if they have come immediately, then the High Court will be much more liberal to quash the case. But if a person comes after, say, in the verge of completion of trial, or after the trial has been completed, then the High Court should not be entertaining such matter. But, Your Lordship, in 2019, the Honorable Supreme Court has clarified that because we have to look at the injury, so that's why it's better that all the evidence should be collected, and after that the trial should proceed. Then that will be the best stage to decide on the quashing, not immediately while the investigation is pending. So, Lordship, here in this case, the evidence of the doctor has been taken. Trial has commenced, the evidence of doctor has been taken. Lordship, I'll take Lordship to the evidence of the doctor. That is at page 41, Lordship.
Yes.
I have received summons to appear and depose before the court today. I joined service in the year 1996 as medical and health officer. In the year 2017, I was posted at Civil Hospital Joy as senior medical and health officer, and presently I am posted at Cleariat as the DM and HO. On 21st February 2017, Sri Endelis Lamre, who's the victim in this case, Lordship, was brought to the hospital by the police. I conducted medical examination on the patient at 10:30 p.m. and the findings are so and so, so and so. so and so. The next paragraph, Your Lordship, says injury. I found that there are 2 sharp cut injuries on the scalp, size 3 centimeter and 1.5 centimeter. Scalp bone deep cut. The person has consumed alcohol but was under control. In my opinion, the person suffered grievous head injury. I have also prepared the medical report after examining Sri Endeles Lamare, and the same is marked as Exhibit 3, and Exhibit 3.1 is my signature. That's the in chief, Your Lordship. In his cross, Your Lordship, he has clarified as to what he meant by the grievous injury. By grievous injury, I mean that the injury sustained by the patient is, in this case, may lead to his death. The injury caused may not lead to permanent disfiguration of the head. I am not aware of the legal procedure or section 320 IPC, as I know only the medical term, and severe bleeding is considered to be grievous injury. I cannot remember if the victim was hospitalized. The patient was not in a life-threatening condition when he was brought, considering the pulse and BP measurement. I have noted that the victim has consumed alcohol from the smell of his breath, as at that point of time we do not have a tool for detection of alcohol in a person. The patient in this case was not fully intoxicated, but he was under his senses. So, Lordship, in the cross-examination, Your Lordship, the doctor has clarified what does he mean by grievous. According to him, when he saw that there is bleeding in the head, he has considered that as grievous. And according to him, Your Lordship, this particular patient at that point of time was not in a life-threatening condition. So that is the nature of injury in this case.
But then he says that by grievous injury, I mean that the injury sustained by the patient is, in this case, may lead to his death.
But, Lordship, Your Lordship is correct. If we stop and if we pause at that, Lordship, then perhaps what he has conveyed may stand, Your Lordship. But if you look at the further...
As we proceed below, we should forget what he has said at the beginning.
No, we have to read it harmoniously, Your Lordship. All I'm saying is that we have to read it harmoniously. So in the paragraph below, he has clarified, Your Lordship, that in this case, the person...
How this harmonious construction will be given here? His same evidence, he says grievous means something which may lead you to death.
But at the same time, Your Lordship is right.
He has not said that it is not a case of grievous.
Your Lordship is right in that aspect. But Lordship, if we look at the evidence of the doctor has clarified that by grievous is also meaning he saw the blood. That's why he, in his view, according to him, that amounts to grievous injury, and he doesn't understand the technical definition of grievous.
Looking at the blood is one of the factors, not the entire.
Yes, Lordship. It's one of the factors.
He did not say that I did not look at any other factors.
Yes.
It is solely on the basis of the bleeding which I saw, I have said it. He did not say that. Your evidence has not clarified it to that extent.
But Lordship, another aspect to this, Your Lordship, he has clarified that there's no permanent disfiguration, which is necessary for 320. Because if we look from the legal aspect, the meaning of grievous injury, we have to look at the definition which is emphasized under section 320 of IPC, Lordship. There, the legal definition of grievous injury has been mentioned. So now, one of the conditions for categorizing a injury as grievous injury is permanent disfiguration. Here there's no permanent disfiguration.
If you say that whatever you have submitted, like the 2019 decision, the Apex Court did not say that just because there exists grievous injury, it cannot be compromised. Did not say it.
Yes. Other factors need to be...
which way that grievous, once you have compromised now, okay, and say supposing, if you can project a case, that there was basically no serious intention on the part of the accused to commit a crime.
Yes, Lordship.
Okay.
Yes.
At least with there was no kind of, you see,
mens rea or anything.
Mens rea and all.
Yes,
see. So in such a case, definitely I think a compromise can be accepted.
Yes, Lordship. So that is my second limb of my submission, Lordship.
No, you are harping so much on grievous injury. That is what you see.
Yes. No, that is the first aspect, Lordship. But coming to the second aspect,
at least there is no dispute to the fact that you are not disputing that he has not received grievous injury.
Yes, Lordship.
Now, what is the extent of grievous injury? Okay, that is what I don't think we can determine it from here.
Yes, Lordship. Yes.
Okay. Now, probably the law prescribes to establish that there is a grievous injury. a person must be treated as indoor patient for some duration of time.
Yes, 320, Your Lordship. 320 gives a list, various list, Your Lordship, under
And
which...
I think it prescribes a minute period of time.
Yes, yes, sir.
For which he must be indoor patient, isn't it?
If I may take, Your Lordship, to 320, Your Lordship, of the
No, what is the period it says?
I'll just take, Your Lordship. Here it says... there are 8 categories under which we can categorize an injury as grievous. Lordship, the point which Your Lordship has mentioned is in category 8. It says here, any hurt which endangers life or which causes the sufferer to be during the space of 20 days, Your Lordship. 20 days in severe bodily pain or unable to follow his ordinary pursuits.
So he did not remain in hospital for 20 days?
No.
No. How do you say?
Because, Your Lordship, they are here to clarify that the accused is here to clarify it, Your Lordship. He was there only for about a week, Your
Is
Lordship.
it not something which can be proved by production of document? Man may lie, a document will never lie.
Yes, Your Lordship. Your Lordship, for that, because if we have to go to that extent, because the trial is still going on.
See, depending on what
so we can always bring that as a defense witness in the course of the trial. But at this stage, Your Lordship, at this stage, since the accused is here, or since the complainant and victim is here, Your Lordship, they'll be in a better position to clarify. But as per
supporting your case, so victim has basically enough.
Yes. So here they have given 8 categories, Your Lordship. First is emasculation, then permanent privation of the eye, of the sight of the either eye, then permanent privation of the hearing of either ear, privation of any member or joint, destruction or permanent impairing of the powers of any member or joint. 6 is permanent disfiguration of the head or face, then fracture of or dislocation of the bone or tooth. Hereby a question was asked to him whether there's any permanent disfiguration, because the area where they have claimed that injury was caused is in the head. And as per this 320, Lordship, for an injury in the head to be categorized as grievous injury, there has to be permanent disfiguration of the head. And in this case, Your Lordship, a question was put to him specifically, is there any permanent disfiguration? He said no. So, if you look legally, Your Lordship, the injury suffered
Whether
here might
victim was examined.
Yes, Lordship.
Whether victim was examined.
Yes, Lordship.
What is the evidence of victim?
Yes. Now I'm coming to the second leg of submission, Lordship, regarding the intention. And from the deposition of the victim.
Where is the deposition of victim? Have you?
Yes, Lordship. Because why I'm saying this, Lordship, because if we read the deposition of the victim in this context, Lordship, to see what is the intention of this person, it'll be very clear, Lordship. In my humble and respectful submission, there's no intention, there was no mens rea at that point of time, and the deposition of the victim will demonstrate this, Your Lordship. Lordship, I'll take Your Lordship to the deposition of the victim, which is at page 40, Lordship.
One four.
40.
40. Yes, Mr. President.
I received a summon to appear before the court. I know of the case as I am the victim. The incident occurred on 21st to 2017 at around 8:30 p.m. On the day of the incident, I was in the house of Shrimti Lian Lamare, along with Hamran Sungkon, PW4, Shri Ting Sajam, PW9, and Shri Yon Pran, having alcohol. And suddenly the accused person, Kinifas, for no rhyme or reason, hit me on my head with a dowel 3 times, and then I can feel that I was bleeding and became conscious. Before I lose my consciousness, I only heard the voice of my nephew, Shri Raman, shouted for help. I remember that I regained my consciousness at civil hospital, Yalong. Then I learned that my brother and the VPP has lodged the FIR against the accused person, Shri Kinifas Tengah. The cross-examination says it's not the fact that there's any enmity between the accused and me. Prior to incident, I was examined by the police. Lordship, on the face value of this deposition, what was clear, Lordship, that the petitioner in this case they were sitting, they were drinking alcohol, and all of a sudden here, smashed his head.
This deposition was recorded on 24 July 2019.
Yes, Lordship.
When you attend compromise here, in this case?
This case, Lordship, it was under, we executed compromise on this year, Lordship, August 2023.
August?
August 2023. 10 August.
Recent one?
Yes, Lordship. Very recent. Because, Your Lordship, after this incident, the family ties are sore. That's why now, to normalize that, finally they have decided that let us enter into compromise. And I'll take Your Lordship to the compromise deed also. There in the compromise deed, it will throw more light as to the position of the victim in this case, Your Lordship. I'll take Your Lordship to page 48, which is the compromise deed, Lordship.
What is the stage of trial? What is the stage of trial?
Evidence is still proceeding now. Prosecution evidence still proceeding.
Your Lordship, I just wanted to bring that to your Lordship's notice. The number of prosecution witnesses cited were 12. And the number of, they have already examined 12 witnesses. I understand that the matter is almost at the end of the...
313 was examined?
No.
Not yet. 313 is not, even the IO has been examined, Your Lordship. So all the 12 witnesses, prosecution witnesses have been examined. The matter is now coming to an end.
Your Lordship, if I may,
So whether
I totally...
The timing of the compromise, their prayer for quashing the case should also be taken into consideration by your Lordship.
Lordship,
This matter is coming to an end. It is for the Sessions Court to decide now whether what is the involvement of the petitioner or the
But then
accused.
you said 313 has not been conducted.
313 is not
Then
done.
there may be a question of defense
Yes,
witness.
exactly,
also.
exactly, Lordship.
Okay.
Because 12 prosecution witnesses have already been examined, and this was examined. They had already been examined when this case was filed. So by now, maybe 313 is also done.
You say the
I'm not sure about
compromise
that.
was attained on 10th of August.
Yes, Lordship.
Now, whether any witness was examined thereafter?
No, Lordship, no. No witness was examined.
Whether the fact that there exists a compromise, was it brought to the knowledge of the prosecution there or the court below
Lordship.
there?
I do
Not yet.
not think so.
Not yet, Lordship. Not yet.
And the trial has also not been
Why do you
suspended.
come for that option only for these things? Even you have some remedy available before the trial could
Lordship,
also. You can seek withdrawal from prosecution if you can convince the PP there.
With all due respect, Lordship, I'll be the happiest person if the trial court disposes of the matter at their level, Lordship. But your Lordship will appreciate that in this case, 307 is involved, which is non-compoundable, Lordship. And we see very well that in the
Withdrawal
trial...
from prosecution, you do not need 320.
Because in the trial stage, your Lordship, when it comes to session cases, Lordship, the prosecution are very reluctant to withdraw prosecution, Lordship. Unlike if it's a magisterial
you can say
cases
it once
or-
you approach there. You have not approached, not made a approach there. Till now. Okay.
Lordship, with all due respect, that has been the practice and convention there, your Lordship, that once the matter comes to session court, Lordship, there is hardly any withdrawal, Lordship.
Even when there is no evidence.
Lordship,
That means you say 321 is redundant, so far it will not
because
be applicable
everyone
with
wants
the
the court to pass the order, your Lordship.
See, we do not go by practice. If law says one thing, then definitely we say that an opportunity is there.
Yes, Lordship.
Whether you adopt it in practice or not, that will not negate that very provision of law. It will always remain. It will always remain there. Of course, you say like whether there should be withdrawal from prosecution or not, that is sole prosecution, the
Exactly.
prerogative of the prosecution.
Yes, yes.
Okay. So not saying that, but then at least there should be an effort to do that. You see.
Because
Okay. Now you basically come attain one compromise. That also at the end of the recording of all the PWS. That is not. Is it not something that say like it may happen like that? You find that all the evidences are against you.
No,
and
no.
you may have every likelihood of
no, Lordship,
being
because
convicted.
Because your Lordship, I understand your Lordship anxiety when it comes to this matter, because it's in the prosecution has led their evidence, and your Lordship has pointed out that perhaps we are doing this just to safeguard our interests. But your Lordship may kindly appreciate this fact that when we compromise, it is not a one-way track, Lordship. It involves two persons here. it's not only us who wants this, but it's the other side also who wants. If it would have been in our power, Lordship, we would have done it right from the beginning. But Lordship, because, as I've said, because the family tie has sore, and we were not in talking terms all this time, Lordship, and then finally good sense prevailed. As we know, Lordship, by human experience, with time, sometimes some pain gets healed. So that's what has happened in this case also, Lordship. With time, good sense prevailed, and both sides have come. Both sides have come and expressed the intention that we want to compound this matter. Now, coming to that other aspect as to whether it's legal or not, to come at the stage when the prosecution is at the watch end of their evidence. Why I'm saying watch end of the evidence, Lordship, because till date the matter is fixed for evidence of the prosecution. 313 has not been called for. Lordship, in my humble and respectful submission, the 2019 judgment of the Honorable Supreme Court has clarified this point. They said that only when evidence are collected, and especially the court has expressed that perhaps the trial should be there also, then we'll have enough materials to decide on such quashing. So we are not in the fact, and we're not too late for quashing, Lordship. And as your Lordship has pointed out, when you talk about trial, it's not only about the prosecution. We defense also have the right to lead our defense witness. So now perhaps the trial is only at its 50% of completion. Another 50% is left for us to lead defense and everything. So Lordship, in my humble and respectful submission, we are not too late. And this is not an endeavor to protect my interest alone, because here the interest of the other side is also there, Your Lordship, to normalize family ties. Because we are belonging to the same village.
No, but then what about your conduct? You have
conduct, Your Lordship.
See, because of your action, the resources of the state has to be used. Police has to undertake investigation. It involves the money of the taxpayers. Okay, now can it be something like that? That in all cases, the criminal matters, whenever there is a commission of offence and all, police investigate, charge sheet is filed, the trial is going, and then parties take compromise, and the matter ends up. Can it be a rule?
Can it be?
Can it be a rule? Can it be a rule?
Lordship, there have been instances, Lordship.
See, this is something which should be
perfect scenario, as Your Lordship has
should be in rarity.
Yes.
Can it become a regular course?
No, Lordship. As Your Lordship has pointed out, in a perfect case scenario, Lordship, this thing is not desirable. These things are not desirable at all because it involves payment of, involves the money of taxpayers and everything, Lordship. But these are things that happens in the society, Lordship. These are beyond our control, Lordship. And Your Lordship will look at my conduct. What have I done after this FIR has filed? Did I abscond? No. Immediately, Your Lordship, when I came to know that the village defense party were have informed me that FIR has been filed, I came forward, Your Lordship. I cooperated with the investigation. I was there in the jail for 3 years and a half, Lordship. 2 years and a half, almost 3 years, Lordship. From my part, Lordship, whatever possible way to cooperate with the law agency, I have done so, Lordship. And now a door and opportunity has been opened for these two families to regain their ties once again, Lordship. Lordship, if I may take Your Lordship to the compromise deed, Lordship. Here, yes. Lordship, page 48, Your Lordship, the last paragraph, if I may read, Lordship. The few paragraphs ahead is just an introductory, Lordship, so the relevant paragraph will be the last paragraph. And whereas the victim and the accused are related to one another, wherein the accused is the paternal uncle of the victim, and both the parties are desirous of setting the matter so as to maintain one and cordial relationship between them and the family as before. And whereas considering the fact that the alleged incident took place when both the victim and accused person were in a drunken stage, so this throws more light about the intention of the accused in hitting the victim in this case, Your Lordship. B. There is no ill will by the accused person towards the victim. It was a drunken brawl, Lordship. C. The victim is in fine health now and is not affected by the alleged assault. So there's no permanent disfiguration, Your Lordship. The victim is continuing with his day-to-day work. And lastly, the accused person was in prison for 1,029 days. The accused person has already suffered much, Your Lordship, in this instant case. And as such, all parties hereby mutually agree to settle the matter by way of compromise, and the complainant and victim shall support the effort of the accused person to get quashed before the High Court of Meghalaya or any other court to secure the ends of justice. So we are here for the ends of justice, Your Lordship.
Everyone is before the court for ends of justice.
That's why, Your Lordship, we are here before this court. So the statement of the deposition of the victim himself, Your Lordship, has thrown a light that, Your Lordship, there was no ill will at that point of time. They were just drinking, and all of a sudden, this thing has happened. After this person, what he has done, when he came to know FIR has been filed, he surrendered himself to the police. He went with the VDP. And now let us maybe look at the antecedent of this person, Your Lordship. Is he a dangerous person? Does he have any criminal background? Lordship, for that, I'll just like to draw Your Lordship attention to the arrest memo, Lordship, of the accused person.
Does he have?
No, Lordship.
So there is no criminal interest.
No criminal. Even the arrest memo also shows that fact, Lordship, that he has a clean antecedent, Lordship. Clean antecedent.
Where is that decision of the Apex Court?
Yes, Lordship. Lakshmi Narayan. I berkawai ke kedugaan Narendra Singh and others.
How many decisions you have there?
There are two decisions, Your Lordship.
Which would be more helpful to you?
Both, Your Lordship. Actually, in 2019, to be fair, Your Lordship,
it's a three-judges bench.
Three-judge judgment, and also in that case, the Supreme Court has laid the law relating to 307. But ultimately, when it comes to the facts of the case, the Honorable Supreme Court has refused to quash on certain grounds. I'll satisfy, Your Lordship. So there is one judgment, Your Lordship, because prior to 2019, there's this judgment of 2014, which was not set aside by the Honorable Supreme Court.
Which one are you referring now?
I'll refer to both, Lordship. Firstly, to 2014.
Yes.
Which one is this? Party, sir?
This Narendra Singh and others. Lordship, I'll just take Your Lordship to the facts of the case so that the law can be appreciated, Lordship. If you look at paragraph 2, Lordship, of the judgment.
That 2014 was referred in 2019?
Yes, Lordship. Yes, Lordship. In fact, 2014 lays down the law, Lordship, and 2019 clarifies it. It has not overruled it, but just some clarification here and there, Lordship. Paragraph 2, it says, leave granted, we have heard the counsel for the parties alike. It may be stated at the onset that the petitioner herein, who are 3 in number, have been charged under various provision of IPC, including for committing the offence punishable under section 307, that is attempt to commit murder. FIR so-and-so of 14/7/2010 was registered. In the aforesaid FIR, the allegation against the petitioner are that on 9/7/2010 at 7 a.m., while the respondent 2 was going on his motorcycle to bring diesel from village so-and-so, Jasbir Singh, Narendra Singh, both sons of so-and-so and so-and-so, attacked him and injured him. Respondent 2 was admitted in Sri Guru Nanak Dev Hospital, Amritsar. After examination, the doctor found 4 injuries on his person. Injuries 1 to 3 are with sharp edge weapons, and injury 4 is simple. From the statement of the injured, an MLR report and FIR under so-and-so 323, 24, 334 was registered. After X-ray report relating to X-ray injury 3, section 307 was added in the FIR. After the completion of investigation, challan has been presented in the court against the petitioner and charges have also been framed. Now the case is pending before the Learned Trial Court, Amritsar, for evidence. During the pendency of trial proceeding, the matter has been compromised between the petitioner as well as the private respondent with the intervention of the panchayat on so-and-so. It is clear from the above that 3 years after the incident, the parties compromised the matter with intervention of the panchayat of the village. This is the brief facts, Your Lordship. They went to High Court. High Court did not entertain it, primarily on the ground of these injuries, Your Lordship, because one injury was grievous and it was caused by sharp weapon. So the High Court did not entertain it, Lordship. Now they went to this Honorable Supreme Court, and Honorable Supreme Court, Your Lordship, has has clarified as to why in 307 this quashing can be entertained, Your Lordship, and why it doesn't fall into category of heinous offence. In paragraph 29, Your Lordship, 29. 29.7 specifically talks about offence relating to 307, Your Lordship. Oh, sorry, it's 2.6, Your Lordship, 2.6. Paragraph 2.6.
Paragraph 2.6.
Yes, sir.
The beginning or the
paragraph 29, and then within 29 there is paragraph 2.1, then 2.6 Your Lordship. 29.6, sorry, 29.6. Your Lordship.
So you are referring to 29.6?
Yes, Your Lordship. Offence under section 307 will fall into category of heinous and serious offence, therefore are to be generally treated as crime against society and not against the individual alone. However, the High Court will not rest its decision merely because there is a mention of section 307 IPC in the FIR or a charge is framed under this provision. It will be open to the High Court to examine as to whether the incorporation of section 307 is there for the sake of it or the prosecution has collected sufficient evidence which if proved will lead to proving the charge under section 307 IPC. For this purpose, it will be open to the High Court to go by the nature of the injury sustained, whether such injury is inflicted on the vital, delicate part of the body, nature of weapon use, etc. Medical report in respect of injuries suffered by the victim can generally be the guiding factor. On the basis of this preliminary analysis, the High Court can examine as to whether there is strong possibility of conviction or chances of conviction are remote and bleak. In the former case, it can refuse to accept the settlement and quash the criminal proceeding, whereas in the latter case, it will be permissible for the High Court to accept the plea compounding the offence based on complete settlement between parties. At this stage, the court can also be swayed by the fact that settlement between the parties is going to result in harmony between them, which may improve the future relationship. Lordship, to be fair, 2.7 here, initially, if it is against me, because it says here that if cases are settled at the earliest possible time, then High Court will definitely entertain, but if it's at a later stage, it will be against us. But Your Lordship, this paragraph has been clarified in 2019, Lordship. 2019 judgment has clarified that no, it's not.
Another aspect. What about the possibility of conviction? Now, if that is to be determined, then...
No, in my humble and respectful submission, Your Lordship, with all humility and my command, Lordship, at this stage, in my humble and respectful submission, Your Lordship, we just need to look at these parameters which the Supreme Court has given.
The part which you are referring, it says.
Yes. And that this is the...
High Court can examine as to whether there is a strong possibility of conviction, but the chance of conviction are remote and bleak.
Yes.
Now that is also has to be taken into consideration.
That is one factor.
It cannot be something like that. We take into consideration one line and we see.
Yes. I totally agree, Lordship. That is one aspect. And then there are other several aspects. Another aspect is we'll see whether it will result in harmony between the parties. That's also an aspect, Lordship. The nature of injury suffered, and other aspects also, Lordship.
Yes.
Lordship, in fact, in this case, Your Lordship, finally, on if I just take, Your Lordship, just because I've thrown light this Honourable Court as to the facts of this case, Your Lordship, and as to why the High Court rejected the quashing petition. It was simply on the ground because the injury was serious in nature. Now, if you look at paragraph 32, Lordship, paragraph 32 of the judgment, the Supreme Court says, we find from the impugned order that the sole reason which weighed with the High Court in refusing to accept the settlement between the parties was the nature of injuries. If we go by that factor alone, normally we will tend to agree with the High Court approach. However, as pointed out here and there, some other attendant and inseparable circumstances also need to be kept in mind, which compel us to take a different view. So all these factors have to be taken into consideration, Lordship. It says, Your Lordship, we have gone through the FIR as well as which was recorded on the basis of statement of complaint. It gives an here finally it talks about the possibility of settlement, Your Lordship, as the guiding factor which compels the Supreme Court to quash this petition, because the Panchayat has intervened and both the parties will settle the matter, Your Lordship. So now I'll take Your Lordship to another judgment, Your Lordship. This.
Just hold on. Wait, just wait for a minute. There are many aspects anyway. See, if you rely on this, you come further to the paragraph 33. You see, here the apex court has taken into consideration the other aspect in view of the compromise, that whether the witnesses will come forward in support of the prosecution case or not. Here, this is not your case. This is something.
Another factor that was taken into consideration, Your Lordship, that the Panchayat has intervened in this matter and both parties are to settle.
See, if we go to paragraph 33,
Yes, Lordship.
then definitely it weakens your case.
Lordship, this is in context with that case, Your Lordship. But so far as the law is concerned, Your Lordship, the law is very clear that we have to look at the nature of injuries, we have to look at the antecedent of the person, we have to look at the
these are also the factors
person.
which apex court has taken in consideration. See, these are also the factors which have been looked into.
In this case, it's just that, Your Lordship, they came to the Honorable Supreme Court at that time when the trial was yet to commence, Your Lordship. That's why the Honorable Supreme Court has given an indication at that point of time that if they have come immediately after the crime has committed, then it will be easier for the High Court to quash. But subsequently, 2019, Your Lordship, has been clarified.
But in 2014, you are relying upon, isn't it?
Yes, Your Lordship. I'm relying on the law, Your Lordship, the law of this.
Definitely. What is stated in 33 also is also law.
Yes, in context of the facts of
law. Just because it doesn't support you,
I totally agree with Lordship, but the only caveat to that, Lordship, if I may add, is that this is in context with that facts of that case, Lordship. Here our facts is slightly different, Lordship.
Yes, and then 2019?
Yes, 2019. Paragraph 15.4, Lordship. Lordship, just the background of this case, Your Lordship, is in paragraph 1. It says, a two-bench of this court, while its order dated so-and-so, in view of the apparent conflict between the two decisions of this court in Narendra Singh v. State of Punjab and State of Rajasthan v. Shambhir Khan, has referred this matter to a bench of 3 bench, and that is how the matter is placed before the bench of 3 judges. Lordship, paragraph 15 is the finding of the. Now the question that was there at that point of time was whether 307 can be quashed or not. So in paragraph 15.4, in fact the 3 bench, Your Lordship, they have reaffirmed what was observed in the Narendra Singh's judgment, but they have just clarified as to the timing, as to when we should approach the Honorable Supreme Court.
Let us see what paragraph 15 says.
15.4, Lordship.
15.4. Yes.
Offences under Section 307 IPC and Arms Act Extra will fall in the category of heinous and serious offences, and therefore are to be treated as crime against the society and not against the individual alone. And therefore the crime proceedings for the offence under Section 307 IPC and or the Arms Act Extra, which have a serious impact on the society, cannot be quashed in exercise of powers under Section 40 on the ground that the parties have resolved the entire dispute. However, the High Court will not rest its decision merely because there is a mention of Section 307 IPC in the FIR or the charge is framed under this provision. It will be open to the High Court to examine as to whether the incorporation of Section 307 IPC is there for the sake of it, or the prosecution has collected sufficient evidence which, if proved, will lead to the framing of charges under Section 307. For this purpose, it will be open to the High Court to go by the nature of the injury sustained, whether such injury is inflicted on the vital delicate parts of the nature of weapons used extra. However, such an exercise by the High Court will be permissible only after the evidence is collected, after investigation and the charge sheet is filed, charge is framed, and or during the trial. Such exercise is not permissible when the matter is still under investigation. Therefore, the ultimate conclusion, paragraph 22.6 and 29.6 and 29.7 of decision of this court in Narendra Singh should be read harmoniously and to be read as a whole and in the circumstances stated here and above.
You say it helps you.
No, it clarifies about the state, Your Lordship.
But then what about the proposal? See, there are two things. See, like if you go by the words here, the court says normally 307, it's a crime against society. You see, there should not be, you say, like, it should not be quashed normally on the basis of compromise and all.
No, if I just may add, Lordship, just to add to that, Lordship, this is spoken in context of 307 read with the Arms Act, because in this case, Your Lordship, and Arms Act, because in this case, why this Arms Act came to
further. It is not only Arms Act.
Yes.
Subsequently, you come for the offence under 307 of the Arms Act and oblique or. So it can be either 307 or Arms Act. Not 307 and Arms Act.
But Lordship, why I'm saying this, Lordship, because if you look at the judgment of the Supreme Court, Lordship, in those cases where, say, weapon like arms is used, Your Lordship, usually the Supreme Court doesn't quash, Your Lordship. But if it's other arms that's being used, if it's other weapons that's being used, the Supreme Court is quite liberal to quash such cases.
We are not on those things. Our thing is basically is purpose, because we are confined to 307. We are not going to Arms Act. Now, you see, it is 307 and oblique or Arms Act. So when it is 307 also, this has to be regarded as an offence against the society.
Yes, Your Lordship.
Okay. Now, and it says that it has a serious impact on society and cannot be quashed in excess powers under 482. Now, the part which you are reading, it says, see, however, the High Court would not rest its decision merely because there is a mention of 307. Now, what does it mean? Means 307 has been mentioned, but then there is no supporting evidence. There we can say the mere. Now, in your case, it is not that. There exists a medical report. There is medical evidence. Now, what is the ultimate, merit of all those evidences that we will not do, may not go and decide at this stage. But then it cannot be a case where you can say that 307 is merely mentioned. There are materials to support it. The acceptability of materials, we may not decide at this stage.
Lordship, in my humble and respectful submission, Your Lordship has pointed out that 307 is a crime against society. I bow down to that, Lordship, and if I may add another dimension to that, Lordship, family is an institution of the society. The first institution of the society that is affected because of this entire incident is the institution of family in this case, Your Lordship. Our family ties were turned sore because of this, Lordship. Our family ties got affected because of this. So it is the first institution of the society that got affected. And now, Your Lordship, now through this endeavor, Lordship, we are trying to mend things way, Lordship, to trying to normalize relationship once again, Lordship.
That is so far as your private interest is concerned. What about public?
No, because
what about the crime against society?
Because family is also an institution of the society, Lordship. And in this case,
society,
if you look at...
You see, the individuals constitute society.
Exactly. I'm just saying family is part of the society.
Alone I am private, but then when I am together with you, I am a part of public. So that is what.
But here in this case, the main institution of the society that got affected is the family, Lordship.
You see, probably when we started the view of the court was something. But in reading these provisions and the special decisions which you have cited, that make things tougher for you.
Yes, Lordship. No, because Lordship, with all due respect, Lordship,
If you minutely read it.
Yes, Lordship, with all due respect, Lordship, in my way of thinking, Lordship, we have to play our cards before this honorable court in the most fairest way, whether it's against us or for us.
Definitely.
When I was reading
Mr.
this judgment, Lordship, I understood that perhaps this judgment could be against me, but it's my duty as the officer of the court to place it before this honorable court.
Definitely, we appreciate it. You see,
Which I have done, Lordship. But, Lordship, now, in my humble and respectful submission, if we read at this judgment, Lordship, Narendra Singh judgment and all, it doesn't close the door for this court. If we look at the facts of Narendra Singh judgment's case, Lordship, what has happened in that case? In that case also, injury was inflicted, and that also not one injury, Your Lordship. There were 4 injuries that were inflicted. And not only that, Lordship, one injury was also very serious. But in spite of that, Lordship, in spite of that, the door of 307, the fact that 307 was there didn't close the door of the court to quash the matter at hand. Because why? For them, the paramount factors they took into consideration was that the panchayat has intervened, and then there's a possibility for these two varying factions to come together, to bring them together, to make the society in a much better place.
Now,
so although Your Lordship, although there was materials even in Narendra Singh judgment's case, that's why I've read the facts of the case, Your Lordship. There were 4 injuries. Sharp weapons were used in that case. But in spite of that, Lordship, what outweighed all these things was the fact that the peace will prevail among the parties. Society will be a much better place, Your Lordship. That's why the case was quashed. Even in our case also, Your Lordship. That's why I'm saying here, which institution of the society is affected greatly because of this incident? It is the family institution of this 2%. It is this institution that has been affected,
Then
Lordship.
it becomes individual consideration. We have to take into consideration the public, the larger public interest.
That may be there, Lordship. I'm not denying that fact. I bow down to that.
You see, it is not a basically, you can say, like a incidental or ancillary things. You see, this is the main issue.
I totally agree with your Lordship on that. But all I'm saying is that, Lordship, that just as the Supreme Court took into consideration the fact that peace will prevail among those 2 warring factions, even here, Lordship, that can be taken into consideration.
If you say, like this
Because
paragraph 15.4, which you referred to this Lakshmi Narayan case. Now there also, if you go to the last part, okay, which you say that after recording of evidence and all. Now that way, you see, like things become more tougher for you, see. Now after recording of evidence, if you go by the exact meaning, purport what has been said in that paragraph 15.4, the apex to say that when there remains a mere existence of section 307, even after the evidence is recorded. Now that has to be construed that way.
But what I'm trying to, because that is what
you are harping more on those issues. You see, the family relation and all. But then if you compare private interest and public interest,
no, Lordship.
Interest will overweigh this thing.
No, because Lordship, here, in fact, I'm in a much better footing than in Narendra Singh's case, Your Lordship. Because here, when you talk about the injury, Your Lordship, we talk about the injury here. Here, it is just the opinion of the doctor that the injury is grievous in nature. But if you look at the legal definition, Lordship, nowhere does it fall under any of the category of grievous offences.
No, but then you are not be able to give that the code that how long he was treated as an indoor patient and all. Now these facts, if you can, this may help us in coming to those things.
So I may, with your permission, then file an additional affidavit to bring that on the court.
If you can determine, that will be very, very good. This will help. You see,
yes,
it is not that the court also would like to drag on with the case.
I understand, Your Lordship.
Which is likely to be compromised.
Yes, Your Lordship.
But then the thing is that, you see, like, we are bound by law.
Lordship, if in that case, then I'll be given permission that I'll bring that by way of affidavit, Lordship.
Of course, let us see what if prosecution doesn't object, then you may not have to do it.
Yes, Your Lordship.
Let us see.
So that's my case, Your Lordship.
I think you have, more or less, you have finished.
Yes, Your Lordship.
Let us see, depending upon what they say, then if you regret that, then
yes,
Your Lordship.
May it please, Your Lordship.
Yes, madam, you are objecting.
Your Lordship, it is not a case of objection. If the citations which my learned friend has taken, Your Lordship, extensively to the background and the antecedents of the 2 parties,
Yes,
the victim and the accused, Your Lordship, it's no need for me to repeat all that, Your Lordship, but I just want to take Your Lordship to the very fact that on the filing of an FIR, Your Lordship, investigation case was registered, investigation was carried, and charge sheet filed under Section 326 and 307, Your Lordship.
When was charge sheet filed?
Charge sheet was also filed in the same year, if I'm not mistaken.
2019 itself.
2017, Your Lordship. Same year.
FIR is of 2017.
Yes, the occurrence took place on 21st of February 2017. FIR filed on 2 days later, and then the investigation was taken up, and the charge.
25th for 2017.
Yeah,
25th for 2017.
So that means 2 months later.
Very fast.
Very fast.
Because we cooperated, Your Lordship.
But immediately after the incident, Your Lordship, if I may.
See, they are out to get all the advantages. He is ready to.
Yes, no, immediately after the incident, Your Lordship, both of them were drinking in somebody's place, and then immediately after the incident, the accused, he hit the victim with a dao on his head, and he was seriously injured, and the accused person fled away. It was only after the VDP came into the picture that he also had to come, because he would not have been.
So it is not what he exactly says that,
that
he went
did
and
not
incorporated.
flee. It was only after the VDP came. That is what is the evidence of the prosecution witness. That is number one, Your Lordship. Then, now, Your Lordship, when the charge was framed, that time they could have argued that there is no case under Section 307, which was not done. They participated in the trial, and now, after the evidence of the doctor has come, Your Lordship, they have, after how many years, about 7-8 years later, Your Lordship, they have come with a compromise. Maybe it was because of the efforts of the well-wishers and family that they have now finally come to compromise. But, Your Lordship, just because two individual private parties compromise, can the crime be wiped away, Your Lordship?
That is precisely the question. Is that
Can it be wiped away? Because 307 comes under the category of heinous offence, and it has an adverse impact on the society. Exactly. So, Your Lordship, if we are to treat such compromises and quash the entire proceedings in a lenient way, then, Your Lordship, what happens, Your Lordship? More offences come. People are encouraged. This 307, Your Lordship, has to be taken so as to teach the the offenders a lesson, and also to discourage other like-minded people from committing further offences and putting the society at some danger, Your Lordship, from such people. Now, Your Lordship, my friend has been repeatedly saying that it is two parties, warring parties have come, they have decided they will live in harmony. Yes, they too will live harmony, but what about the rest of the society, Your Lordship? Because we have a responsibility towards the society. And because this is a crime under Section 307, Your Lordship, society's interest has to be taken into consideration by this Honourable Court, Your Lordship. And it is not a case that 307 has just been put in this case, in the charge sheet by the police, because if that be so, then they could have argued before the charge was framed, saying that there is no offence under Section 307, which is not the case here. Even the doctor's evidence, Your Lordship, will show that the offence is would have led to the death of the victim, Your Lordship.
That we have noticed in the cross-examination.
Yes, Your Lordship. It says, and the doctor has also said in the chief, Your Lordship, there are 2 sharp-cut injuries on the head. Now, Your Lordship, Supreme Court has said that what is the weapon used? That has to be taken into consideration. Which part of the body has been attacked? Head. Head is a vital part of the body, Your Lordship. He has attacked him on his head. 2-3 blows were given on his head, and he sustained 2 sharp-cut injuries on the scalp. Size 3 inches into 1/2 inches, skull, bone deep. That means the impact was quite forceful. It was skull, bone deep. It had gone it was just his luck that he did not die. And it was also the luck of the accused that otherwise he would have been tried for murder. But here it's a clear case of attempt to murder. So we cannot take it lightly, Your Lordship. And just because they have decided to compromise, the entire case should be quashed. So then even in the cross-examination, he has said, by grievous injury, I mean that the injury sustained by the patient. He is referring to this particular patient, in this case, may have led to his death. And then he says, then in another, he says, I know only the medical term, and severe bleeding is considered to be a grievous injury. Then in the next line, he said the patient was not in a life-threatening condition. Why did he say that? Because he said that his BP and pulse measurement was normal. That is why. But he has said clearly that this patient, the injury which the patient has sustained, could have led to his death. So it was his luck that he did not die, and it's also the accused's luck that he didn't manage to kill him. Otherwise, he would have been tried for murder, as said earlier. So, Your Lordship, my humble and respectful submission is that when a crime under such a heinous crime has been committed, and there is sufficient evidence to show that an attempt had been made on the life of the victim, Your Lordship, whether because just for the sake of two families, the entire society should be put at risk. And these citations, which my learned friend has said, Your Lordship, it clearly says that the timing is also very important. Had they come before at the time of investigation, court could have been
That is what
lenient.
2014 said. But
Yes.
in 2019, 13 said
And
something else.
even in 19, Your Lordship.
But then 2019 speaks about that mere mention of 307. Now
Mere mention.
That is what is.
But this is not a case of mere mention of 307.
That
The
is
doctor's
what-
evidence is very clear that it could have led to the death of this
That is why
patient.
precisely court wanted to do how long this patient was treated as indoor patient. This victim was treated as indoor patient.
As per my knowledge, but in the weak lordship.
Because they say that for this purpose, in 2019 at 15.4, which my friend had read earlier, Your Lordship, for this purpose it would be open to the High Court to go by the nature of the injury sustained.
That is exactly.
Whether such injury is inflicted on the vital, delicate part of the body. This is also vital.
See,
The head
the
is
one
also
thing is-
vital. The nature of weapon use. This is also very
That is what.
down is used.
That is what
However,
the problem
such an exercise by the High Court would be permissible only after evidence is collected. That means in this case, evidence has been collected, investigation is over, charge sheet filed, even the trial is on. And my other submission is that the timing also is there because all the witnesses, prosecution witnesses have been examined.
When the prosecution was last, when the last prosecution exam.
Here, Your Lordship, they have, according to the prosecution, 12 witnesses have been cited. This is in their petition only. And all 12 have been examined. Here, Your Lordship, at page 24.
11 May 2022.
22.
And then till now,
Then
has not been done.
No,
313 could have been done.
No, because the prosecution intends to, I think, bring some other witness. That's why it's listed for further evidence.
But then the number of witnesses that has been cited.
Because of the prosecution.
At page 24, Your Lordship, of the petition, Your Lordship may see that the number of witnesses cited by the prosecution is 12. And the number of witnesses that has already been examined is also 12. Now, whether what further witnesses can they bring, Your Lordship? Because I don't understand.
That opportunity remains.
Maybe
But then whether
because
at all it has been done or not, that is the main thing.
we do not know. And maybe because they have forgotten.
313 has not been done.
So we do not know. For the last 1 year, if 313 has not been done.
Why don't you take, you see, like something concrete should come. It should not be something like you make some submission.
We cannot speculate.
No, because I'm sure, Your Lordship, because today
If
morning also I had.
last prosecution witness was examined in the month of May 2022. It is 1.5 year. Now, definitely this court would like to know what happened in 1.5.
313.
I had a talk with the counsel who was presenting them in the trial court Lordship today morning. He said 313 has not been done, Lordship.
Why was it?
Because Lordship, the prosecution was saying that some evidence will be led. That's why.
No, that is your instruction.
And we are
Is there anything to
speculating.
show on record?
Yes, Lordship. We'll bring the order sheet, Lordship. Please, paper. Everything is in the order sheet.
Yes, how long you were in hospital? You can go it, though I do not know whether it's a part of evidence or not. If it is not a part of record,
Then
how
it-
much? But then we need an information basically just for the purpose of helping.
Yes, yes.
This is coming to a finding.
Then my submission is this: more or less the trial is more or less over, because even the IO has been examined, Your Lordship. So only if 313 is yet to remain, then it is it would be in the fitness of things.
313, if they say correctly 313 is not done, what explanation you will have for not doing it? You are the
That is
prosecution.
I'll also have to find out why has there been so much delay? Why has there been so much delay in examining? Perhaps because of even the compromise was arrived at only this year. So when the matter is almost over, Your Lordship, my respectful submission is that it would be in the fitness of things for the trial court to determine whether the petitioner herein before this Lordship is guilty or not guilty, and whether this court should allow the compromise and quash the proceedings, Your Lordship, when the trial is almost over.
Yes, Mr. Shilla, when can you give us the details of those? Give us the status of the trial. What is the last order and all?
We'll apply a certified copy, Lordship, and bring it before this. A week time.
Give us authentic information. It should not be solely on the basis of your
Yes, yes, Lordship. We'll bring everything on record. That's why we'll file certified copy, Lordship. It'll take us 1 week time.
See, this court has the bitter experience of going by the submission of the lawyer at the end,
No, Lordship, we
finding
will,
something else in
as
the
far as I'm concerned, Lordship, I will not
So-
mislead this honorable court, Lordship.
That is one thing you see, like,
But perhaps I have not appeared much in this honorable court. That's why maybe I don't command that respect, Lordship.
No, it's not that.
But I will definitely bring materials by way of certified copy. Please.
This is more or less over, no? Our submission? Or?
Yes. No, I'll,
So
I'll,
for-
I'll
anyway,
bring.
after the documents are submitted, perhaps there'll be another round of.
let me open up for some other grounds for making submission. Hard. Granted counsels for the parties at some length. During the course of hearing, the progress of trial before the trial court, the status of progress of trial before the trial court at this present stage could not be ascertained.
It's okay that I put that. My notes are there. No?
You see, we cannot say you to give those medical things until and unless it's a part of evidence already, because evidence has already been recorded.
Your Lordship.
This is the information you can provide us unofficially, but then I think officially he cannot ask you to do that.
There is no, it has not been exhibited, which means it is not a part
So
of
that
the
is,
record.
there will be a bar.
For it to become part of evidence, Lordship, if in 313 we tell the court that we'll need defense witness, so through the defense it'll be led.
Then
That
it'll
what
take
you
some
do
more
in your
time.
trial, this court will not advise you. You do not have to take concern with that.
No,
That is
but
solely
I'm-
your strategy. You see,
I'm just saying that
your
it's not
strategy
part of
how you do
evidence.
it.
It's not part of evidence,
If it
Lordship.
is not a part of the record, then I don't think they can bring it by way of an additional affidavit before this court.
Before this,
But this is a query of the court for the ends of justice, Your Lordship.
before this matter is finally decided, the information with regard to the status of the trial this is
For the ends
No.
of justice, perhaps that medical report also be brought in record.
no, that is what is no medical report that we this court will not direct it. Say this will create a confusing situation.
The
Because there
medical report is
it in
already
the mind, but then once if it is not a part of existing record, where is the question of bringing it additional evidence?
For the ends of justice, Your Lordship.
You see, you still, if you say that your defense witness has not been done, you have the options of doing things. Now it is up to you which way you take care of those things. You may have those options of what is the trial is.
Yes, Your Lordship.
They have that option before the trial court, not before
That's
this.
why, Your Lordship,
So let them, that is why my submission is that let them finish the trial over there instead of quashing the proceedings at the fag end of the trial.
no, not fact, Your Lordship, just 50%, because defense, I have to lead the
70-80%
evidence.
is
Your Lordship.
already done.
Because trial is not only prosecution to lead, Your Lordship, evidence. It's for us also. 313 is there for us also to lead. So just 50% of the trial is there, Your Lordship.
Anyway, just what is the last name? Yes. Is status stage of the trial, not status. Information regarding the stage of the trial is deemed to be important. Stop. Accordingly, the petitioner is directed to place before the court the latest stage of the trial, latest stage of the trial pending before the trial court, before the next date. When shall we list it again?
After a week, Lordship.
List this matter after a week. This will remain on the next day. We'll just see, depending on the things. And the other things, if you can procure information unofficially, just give it to us for the satisfaction of the court.
Okay, Lordship.
We'll keep these copies of the citation.
Yes, Your Lordship.
Obliged, Lordship.
Obliged, Lordship.
Second call, item number 15.
1 second. What's the date today? Today is 6.
Yes, Your Lordship, actually senior counsel have just left Your Lordship out of station due to some medical condition of one of his family members. So let this matter be posted up after 2 weeks, Your Lordship, is possible.
My Lord, when the matter was called first, my Lord, I was actually on legs.
Okay, on the request made on behalf of the petitioner, list this matter after 2 weeks.
Obliged, Your Lordship.
Obliged, my Lord.